Hey everybody, welcome to another week of Ivylaw Office YouTube Live with Wilberforce Agyekum, attorney at Ivylaw Office, alongside.
Hi, I'm Jumoke Oladapo, attorney at Ivylaw Office. You're welcome to today's episode.
Thank you. All right, today we're going to talk about adjustment of status. A lot of people know what it is, but they don't know how you are able to do that or what it is when you're going to do it. And then lately, I've had some clients come in that seem a little bit confused about when and how you are eligible and able to adjust that. So I thought it would be good for Jumoke and I to briefly talk about it. We're not going to get into a lot of requirements. If you need more information, please call us and we'll get into specific details for your purposes if you need to, okay? So we're going to keep it brief and just talk basically generally about the eligibility requirements process. So adjustment of status is the process that you can use to apply for a lawful permanent resident status or green card when you are present in the United States. This means that you may get a green card without having to return to your home country to complete visa process. But please note, if you are outside of the United States, you must obtain your visa abroad through consular processing, okay? So determining eligibility, Jumoke, want to talk a little bit about that?
Yes. So U.S. immigration has provided a variety of ways for people to apply for green card, and the eligibility requirements for adjustment of status will vary or may vary depending on the category you are applying under. There are a lot of categories which we're going to talk on today, and you want to know if your specific situation fits into the category that we'll discuss. If it is, please feel free to reach out to us so that we can assist you or advise you on how to adjust status. So listen up right now.
All right. So green card eligibility criteria, categories. To apply for a green card, you must be eligible under one of these categories listed below. What's the first one, the broadest one that most people fit in?
Oh, yeah. So the most popular adjustment of status category is for immediate relatives of a U.S. citizen. That's what a lot of people know about. And the people that are recognized and categorized as immediate relatives are a spouse of a U.S. citizen, an unmarried child under 21 years old of a U.S. citizen, and a parent of a U.S. citizen who is at least 21 years of age. So what that means is that a child needs to be 21 years of age or older to be able to petition for a parent. So those are the immediate relatives.
Those are the immediate relatives that all others of a U.S. citizen or relative of a lawful permanent residence under the family-based preference categories. Those family member of U.S. citizens, meaning you are unmarried son or daughter of a U.S. citizen, and you are under 21 years or older, and you are 21 years or older, married son or daughter of a U.S. citizen, brother or sister of a U.S. citizen who is at least 21 years old, family member of a lawful permanent resident, meaning you are a spouse of a lawful permanent resident, unmarried child under the age of 21 of a lawful permanent resident, unmarried son or daughter of a lawful permanent resident, 21 years old or older. So the family category is based, as you can see, family, immediate and, not immediate, but it's all based on family. Okay, so next.
So another category that we want to look at is the fiancé of a U.S. citizen or the fiance's child of a U.S. citizen. If you're not yet married and you have a fiancé that comes in on a K-1 visa, also known as the fiancé's visa, you're already admitted into the United States on the K-1 visa. You can adjust your status after coming into the United States. Also, if the fiancé or fiancé has a child that they brought with them, to the United States, the child can also adjust status.
All right, those are for fiancés, so pay attention to those. They're very strict a little bit, so make sure you talk to a lawyer about those too, okay? Widower of a U.S. citizen. A widow or widower of a U.S. citizen, and you were married to your U.S. citizen spouse at the time of your spouse, at the time that your spouse died. If that's the case, you may be eligible to go ahead and apply for your green card still. All right, okay, next.
Also, those who are vow petitioners, victims of battery or extreme cruelty can apply for adjustment of status. So if you're an abused spouse of a U.S. citizen or an abused spouse of a lawful permanent resident, you can apply for adjustment of status. If you're an abused child under 21 years of age of a U.S. citizen or a lawful permanent resident, you can apply for adjustment of status. If you're an abused parent of a U.S. citizen, you can apply for adjustment of status on the vow of self-petition.
All right. VOW is big and broad, but it's humanitarian. So again, if you fit in the VOW category, please let an attorney help you. We'll be happy to help you at Ivylaw office. Next category of immigrant visas is green card through employment. I'm going to run through this real quick. Those are what we're commonly known as the EB visas, employment-based one. We're going to go through three. So for one, EB1, that's the first preference visa for employment, meaning that you have extraordinary ability in the sciences, arts, education, business, or athletics, an outstanding professor or researcher, or a multinational manager or executive who meets certain criteria. EB2 are a second preference immigrant worker, meaning you are a member of a profession that requires an advanced degree or have exceptional ability in the sciences, arts, or business, or are seeking a national interest waiver. EB3 is a third preference, meaning you are a skilled worker or a professional, or an unskilled worker, meaning you will perform unskilled labor requiring less than 2 years training or experience. So those are the three preferences in the employment-based category for immigrant visas. If you want more information, please call us and we'll talk to you more about EB visas. Okay? Jumoke. Okay.
Hi, hello. Okay, I'm here now. Another category for adjustment of status that we want to touch on is a physician national interest waiver. So if you're a physician who agrees to work full-time in the clinical practice in a designated undeserved area for a set period of time, and you meet other eligibility criteria, you may be able to adjust status in the United States. Another good one is the immigrant investor, which people call EB5. If you're invested or you're investing or you're actively in the process of investing at least 1,500,000, 50,000, 1,050,000, or 800,000 in a targeted employment area, an infrastructure project, or in a new commercial enterprise in the United States, which will create full-time employment for at least 10 qualifying employees. That's the category, the EB5 category. You can adjust status in the United States, be willing to invest at least $800,000 in a targeted employment area, or $1 million in a project, infrastructure project. You'll get the green card.
All right, so if you got the money, they're gonna give it to you. Just gotta follow the rules and you'll be able to get you an EB5 visa and you'll be able to immigrate to the US or stay put, okay?
And we can assist you with that.
That's right. Any of these things we're talking about, feel free to contact us about it because we can help. That other category is the religious worker visa. if you are a member of a religious denomination coming to the U.S. to work for a nonprofit religious organization, you may be able to get your green card through that. Also, special immigrant juvenile classification. A juvenile who needs the protection of a juvenile court because that juvenile has been abused, abandoned, or neglected by a parent. If you fit in that category, you may be able to go ahead and put in your petition application. And Jumoke, a little bit more about this. Special immigrant juvenile classification requires, it's a bit more involved than others. That requires state and federal, correct?
Correct. So you'll have to get a finding with the state courts. For example, in Maryland, the circuit court, family court will have to give an order that's finding that you're a special immigrant juvenile eligible person. And with that order from the court, you'll apply to the USCIS to be found for to be able to be eligible for that status. And also, if that is approved, you can adjust status up to that. So it's a 2 or 3 step process. But if you know someone who is in the United States, under 21 years old in Maryland, and there's talk here, let us know if they may be eligible.
All right, thank you. All right, next category.
So the next category are for Afghans and Iraq nationals. So if you were an Afghan or Iran translator or an interpreter for the United States government, you can be eligible to adjust status in the United States. If you are Iraqi employed or for the US government, then you can adjust in the United States. If you were employed on or after March 20, 2003 for at least 1 year. Also, if you're an Afghan employed by the US government or International Security Assistance Force, then you can be able to adjust the status in the United States.
All right. Okay, another category. We're getting there. There's quite a few, but we're getting there. Another category is the international broadcaster category. If you are an international broadcaster and you are coming to work in the U.S. as a member of the media for the U.S. Agency for Global Media or a USAGM grantee, means you have received a grant from the U.S. Agency for Global Media. So for broadcasters, that's the category, that's what it would take. All right.
Also, an employee of an international organization or a family member of NATO 6 employee can get their status adjusted in the United States. So if you're a retired officer or an employee of an eligible international organization or NATO, or an eligible family member of such an employee, you may be able to adjust your status in the United States.
Okay, perfect. Now, next is green card through refugee or asylee status. Asylee, if you were granted asylum status, at least 1 year has passed, you can go ahead and apply for your green card. Also the same with refugee. If you were admitted as a refugee and at least 1 year has passed, you're eligible to apply for your green card.
Also, if you have a T visa, T non-immigrant visa, and for about 3 years, or if you're a victim of crime and you have a U non-immigrant visa, you may be able to adjust status as well.
Okay. Now, another area, a broad area is green card for victims of abuse. So we're going to go through a few of those examples. VAWA self-petition, I believe we just went through it, but that is also will be considered victim of abuse in that category. So I'm not going to go through it again, but that's another category. Go ahead, Jumoke.
Yeah, some of those categories we've touched on. So victim of abuse could be an SIJS category as well, or an abused spouse or child of a Cuban native. or Cuban citizen.
That's another special category. So if you have an abusive situation or battery or any type of situation like that, you want to talk to an attorney about your situation specifically. Okay, so there are a few other categories. We'll just go through those quickly. Jumoke?
Yes, so there's some categories that the government have created that we call other categories, and those are like special programs that the government has made available for people under certain acts, and these include LIRF. Those are for Liberians. So if you're a Liberian national who has been continuously physically present in the United States since November 2014, or a spouse or a child 21 years of age, who is a qualifying relative of a Liberian national, you would have been able to adjust status within the period that was provided. I believe that time period might have expired now, but that was available before.
Also, there's the Diversity Immigrant Visa Program. If you were selected for diversity visa in the Department of State's Diversity Visa Lottery Program, you'll be eligible for adjustment of status. And also Cuban Adjustment Act. If you are a Cuban native or citizen, or are the spouse or child of a Cuban native or citizen, you are eligible to adjust your status.
Also, if you're from Cuba and you're an abused spouse or child of a Cuban native or citizen, you can adjust your status.
Good. Dependent status under the HRIFA. We'll break that down for you in a second. If you are the spouse or child of a lawful permanent resident who received his or her green card based on the Haitian Refugee Immigration Fairness Act, you will be able to adjust your status.
All right, and also if you're an abused child or an abused spouse of a lawful permanent resident who got their green card based on HRIFA, you can adjust status.
That's the same thing we just talked about, okay? So just different way of getting. And then there's the Lutenberg parolee. If you were paroled into the U.S. as a Lutenberg parolee, if you want more information on that, you can contact us and we'll help you understand what a Lutenberg parolee is. But you'll be eligible to adjust under that as well. And also Indo-Chinese Parole Adjustment Act of 2000. If you are a native or citizen of Vietnam, Cambodia, which is Cambodia, or Laos, who was paroled into the U.S. on or before October 1st, 1997 from Vietnam under the Orderly Departure Program, a refugee camp in East Asia, or a displaced person camp administered by the UNHCR in Thailand, you would be able to adjust.
All right, American Indians born in Canada. If you were born in Canada, you possessed at least 50% American Indian blood, and you maintain your principal residence in the United States, you can adjust status in the United States.
All right. Okay, and also a person born in the United States to a foreign diplomat. If you were born in the United States to a foreign diplomatic officer who was stationed in the U.S. when you were born, you'd be able to adjust the status to a green card. Go ahead. Okay.
And yes, one important one too for those people that came in on G or A visa who are foreign diplomats, they can adjust status under Section 13. So if you were stationed in the United States as a foreign diplomat or high-ranking officer and you're unable to return to your home country, you can adjust status and get green card in the United States. And if you're a child of such a person too, you will be able to.
All right, we've run through the category. There's one last one, which you may be eligible to register for a green card if you have resided continuously in the U.S. since before January 1, 1972. So if you've been here that long, continuously, you may be eligible to apply for adjustment of status. But if that's your story, you want to definitely talk to an attorney on how you may want to go about that. We'll definitely be able to we'll be happy to help you at Ivylaw office for any of these. So please feel free to contact us. Jumoke, how do they contact our office?
Well, you can reach out to us. You've seen that these are a whole lot of categories. Some of them you are aware of, some you're not. But you can reach us at 301-276-0887. Give us a call today. Also, you can visit our website, www.ivylaw.office.com. And there's a contact page there. You can contact us through that page. And we look up to speaking with you. You can visit our Facebook page at Ivylaw-office. And you can also visit our Instagram page, Ivylaw office. Ivylaw Law Office, I believe. So those are different ways of getting in touch with us. We look forward to assisting you. Remember, our goal is to be able to help our clients obtain legal status in the United States so that they can one day achieve their American dream. We are here to help you. Please connect with us.
All right. Thank you very much for joining us. We'll see you next week. If you have any questions about adjustment status or eligibility requirements, please reach out to us.